no matter whether they're married or they are actually de facto. Okay, it doesn't matter. So it's a partner visa 309. Now we have A20 visa. Okay, this is when the visa applicant is onshore. When the visa applicant is onshore, we launch application. The visa subclass A20. Now we having big rain here. Okay, and then when the visa it's approved, the visa applicant has to be onshore as well. Okay. 309. This is temporary stage visa 309, and then for the second, which is permanent one, the subclass is 100. So 309 to 100. The 2 years waiting period, meaning the visa applicant can lodge their second stage of which is permanent visa after 2 years of their initial lodgement. Okay, initial lodgement, not 2 years after the initial visa approval. Now I'll give you an example. So in 2014, and visa the 309 only approved in 2015, October. Can we lodge the permanent visa in 2016? Yeah, we can lodge it. Yes, we can lodge it. Even they just approve for a few months or a few days. The calculation starts from the date the initial visa application was lodged date. Because the processing time nowadays, it can 2 years period. This it's not a requirement. It is not a requirement, which means you can lodge. You are applicable to lodge one after 2 years of the visa lodgement, but you don't have to lodge. You can just wait there for not lodging it. But the department most time will invite the visa applicant to lodge a visa after 3 years has passed. They will invite them. But it is all right, sometimes they just got busy and they are okay. So 2 years, if you can have a good system within your system, you can tell the client the client agreement you can draft for permanent as well. So we say we look after your permanent visa as well, because you then can charge them up to 5,000 Australian dollar for Australian partner visa. If you just charge them for first stage, you can only charge them. And when it comes to the second stage, these people are already in Australia for 2 years, 3 years. They know the game. They will not come back to you, never able to get another 1,000 to look after the 100 visa. Okay, so okay, are you sure? Yes, sorry. Yeah. So so what I was okay. 309. You want to take the file with the permanent visa. You will say, look, I'll look after your permanent visa as well, because the most of in the stage A20 and 309, you've got everything ready. For the second stage, that's not much work to do. So it's fine to connect money in first stage. Just say, I'm going to cover your permanent visa as well, and I'm going to charge you 4,500, something like this. But it depends on your market. Okay, normally you can at least charge 4,000 for a partner visa. Now, partner visa 309 and 100, this is one package. Okay, when they launch 309, when they come to the permanent one, it will be 100 visa. For A20 temporary stage, it's A20. Permanent one, it's A01. The same requirement. Okay, they can launch a permanent one after 2 years from the date the visa is launch date. Now about review right. That's what we say processing time. So first of all, let me talk about processing time. For processing time offshore, 309 type of visa, it's much quicker, which just makes sense, right? You can't they decided to live together for the rest of their life, and then you tear them apart for 3 years. It doesn't make sense. The process for partner visa is a lot quicker than onshore. Onshore, they'll say, look, you're already here in Australia. It doesn't matter. You have Medicare, you can work full time. It's fine. You just wait, okay? So they have no concern about this. For offshore clients, marriage itself, offshore client, I'm saying this, offshore client marriage certificate is very strong evidence, because you cannot establish other information. Sometimes they just offshore marriage certificates is very weak evidence, because they live together. They have to have a financial, they have to have other very strong evidence. So when we deal with the clients, we will know what kind of information we should ask. Now, so this partner visa I just talked about, this is one type, okay? This is offshore, this is onshore. Now, the other type of visa is prospective marriage visa. This visa is really, really interesting, very interesting. The requirement for prospective marriage visa is actually that applicant and sponsor only need to meet once, okay? Once. So I fall in love with this person, we're gonna get married very soon. Prospective marriage visa meaning that the sponsor willing to sponsor the visa applicant, that he or she can enter Australia and then can get married in the future. Okay, this is an intentional type of visa, meaning I just want to get married in the future. And the marriage itself does not need to be taking place in Australia. Okay, so that's it. No, just me sponsoring. After which, I just wait offshore. I will just wait in South Africa. Then marriage visa is approved. Prospective marriage visa is approved. Then John Smith can travel back to South Africa. We get married there. But there is a limit time. Sorry, you hear my this is storm here. Can you hear me well? The sponsor, they can get married anywhere, but the visa applicant must enter Australia once within 6 months. She has to enter Australia. She has to come to Australia. They can get married anywhere else. And sorry, I got very terrible storm here. Oh my god. Yeah, no, we have storm here tonight. It's like hitting my roof. Okay, so marriage itself has to be taken within 9 months of the visa approval. 9 months. Exactly, it's intentional marriage. Now, what happens? I give you guys. We actually got married before the prospective marriage visa is approved. So they just lost visa today, for example. So 3 months ago. Now they haven't got visa yet. The visa applicant hasn't got a visa, but they'll decide to get married today, and they got married. So what's going on? What do you think will be happening? You can type your answers down. Anyone? Any questions? What do you think? So they got married. Not everybody knows what's happening. Okay, so yeah, I'm waiting. Take some. Okay. Yes, sorry. Yes, I will repeat. Marriage. For example, the sponsor, they want to get married. They say, I'm going to get married. So the prospective marriage, it's required that the sponsor and the visa applicant must get must get married within 9 months of the visa approval. So they're not supposed to get married before the visa is approved. Now, what happens if the visa applicant and the sponsor, the prospective marriage visa is approved, they got married? They're not supposed to. They must, they must get married within 9 months of the visa approval. Let me just clean. Very good question. Very, very good answer. It is in that it's the case. If they got married prior to the visa approval, then the subclass 300 will change to 309. And then the department will connect the remaining immigration fee. Because remember, 309, they charge 7,241, I believe. The 300 themselves, they only charge for, I think it's 2,000 something. But then they got married. So then they will process as a class 309. Okay, they will process as a partner visa, and they will not start a process again. They'll be waiting in the queue as they have already waited for 6 months. So if you have a client with a new scenario, don't worry. Of course, we they have to pay more in total because they have to pay 2 separate installment. We can just simply tell the department. We say, oh, wow, I know, I'm sorry, but that's marriage certificate. Can you please? And then you have to request them. Can you now process this visa as a subclass 309? And the client is willing to pay the remaining immigration fee. We have to tell them, because if you don't, they just don't do anything. They just wait for prospective marriage and they get approved. Then ask, hey, can you get married now? They already married, right? And they have to lodge this 820 again, right? So it will be a lot of cost for them. Visa, what happens to marriage visa now? This is in a situation where the visa applicant and sponsor have literally just met once. They met in a pub. They say, oh, I'm going to get married with you. So what can you not partner visa? No, because there is a commitment requirement for partner visa, either onshore or offshore. So commitment means they have something shared, financially, emotionally, or spiritually. Everything they have shared. Some, in theory, you can't demonstrate that part of evidence. You can't. If someone just met a very short period of time, we would encourage them, say, let's do a prospective marriage first. And they will say, oh, if I get married? Say, we don't tell them the outcome. We're going to inform them. We're going to say, look, we look up the file. We know what to do. You just do the, give us the direction. Let us know. Let us deal with you. So we don't tell them, because election lawyer, they have no idea. It's just thinking, oh, what's going on? They have no. So this is within the policy. They can be done this way. If the client just met once, we do prospective marriage visa, but the cost will be so the cost will be extra, isn't it? Because we have normally, if we got partner with visa, we just do 820 or 309, and we pay one immigration fee, 7,000 something. But if they just they have to notch a prospective marriage visa, so the process will be once it's married, they have to lodge this A20 onshore. Okay, why is onshore? Because of course I just mentioned the visa applicant must enter Australia once. So they will lodge onshore application partner visa and then lodge the A01. So that will be a cost, and that is free, but they have to pay this part as well. Although they don't pay the same amount as a fresh A20 visa applicant. Okay, they don't pay fresh, but in total they have to pay more. Right. Okay. So it is a little bit complex here, especially in a case where they don't have a strong evidence, and so applicant, they say, I'm going to lodge a partner visa, and they believe the marriage will be helping them to get visa soon. That is wrong. That is wrong thinking. They should not think about this way, because if someone just travel back to South Africa, get married there, they have to show a lot, and waiting time is a very, very long time. For prospective marriage visa, processing time is no more than 9 months. For partner visa, look, 12 months, 18 months. That is no. Having someone to sponsor marriage certificate, it's not a strong evidence. Sometimes it can weaken the case. Because the department will think that this relationship is not genuine. That person only wants to get to Australia, and then probably pay the sponsor to get them sponsored. So they just don't do anything. They just got married. So marriage itself does not have a lot of weight here in Australia for the purpose of if the client comes to us, we say, wait a minute, even you want to get married, wait a minute, let me hear about your story. Okay, maybe getting married is not the best way you can do. You can get married, okay? So we can lodge your prospective marriage visa, right? And you decide to get married next month, just do so, all right? But if you got married and then you have to lodge partner visa subclass 309, it's a lot harder, and waiting time is very long to get it approved. Definitely advise clients in this regard. Okay, I just give another scenario, which it's not rare. It's very rare, but if you understand family law, you will know this scenario. So we got a client who approached us, whose marriage was deemed invalid because his previous divorce taken place. So they got legally divorced in certain day. It's a period, which is, that it's 1 month and 1 day. Okay, 1 month and 1 day. That person can be remarried. So the person is divorced today. Next month, can they get married? No, they have to wait 1 month and 1 day, calendar day, month and day. We got a client who actually just 1 day in short, who got married. They calculate wrongly. They got married taking place, and that marriage itself was deemed invalid. So, but what happened? Because I just mentioned, marriage itself is not important. Why now a invalid marriage, meaning the visa will be refused? This is because marriage itself does not have strong case to support their relationship, but has a special purpose. So I'm going to go down the next slide. Okay, so I switch this. Okay, let me have a look about this one. I don't think I have covered this one in the slides, but let me just go through. So they have a special purpose. Is that the general requirement of a visa approval is that the visa applicant and sponsor must live together under the same rule for 12 months. They have literally needed, if they never live together for that 12 months, that marriage certificate can waive the residential requirement. Okay, that is the requirement. So the same thing to the de facto relationship. In Australia, two people, they don't have to get married. They can register that de facto relationship. So it is really informal here in Australia. To register in Queensland, the requirement is that two of them sign on the form, statutory declaration form, to declare they want to share, have a shared life. They don't need to have a witness. They don't need to have a ceremony. They don't have nothing. So they just sign a form, and this form sent to the registry office, and they send you certificate down. The requirement is one of them has to be resident of the state. One. Can be offshore, and then can sign this. Yes, it can be done. So when I mentioned marriage certificate, de facto relationship certificate, they have the same value in our partner visa applications. Although for the family law, especially when they deal with the custody, they have different values. In partner visa applications, the marriage certificate has the same value as a de facto relationship registration certificate. 12-month residential requirement. Now, the client I just mentioned who got visa refused was basically because his marriage was, at the time of lodging, his marriage was invalid. So when he lived with the sponsor, they never lived together for 12 months. They only lived together for 6 months. So hence, as a consequence, he could not meet the 12-month, got refused. So yeah, they were quite shocked. And then I checked, what, you got married too early? they thought I've already got divorced. But under Marriage Act, you can only get married again 1 month and 1 day. Okay, so there's 3 type of visa. One type of partner visa, and different needs have a different requirement. Offshore and Australia, when the time to apply the permanent one, they apply 100, class 100. When the visa applicant is onshore, when lodging application, A20. And then the permanent stage is A01. What happens if they have dependent? So the visa applicant has a dependent of her own or his own. It's not the sponsor's biological child. If the child the application added together, they lodge together. So we've got now dependent child. This is have definition. Okay, we will need to say dependent child, it's biological child or legally adopted child. It has to be under definition of a child under the Family Law Act. So the child, when at the time of lodgement, they add together, say, I'm going to 2 children going to migrate with a visa applicant. They will have same subclass. And the child is A20 as well. Sometimes, which is really, really common, that the child is added after the mother's visa is approved. So then you lodge a subclass 445. Why this is happening? So I'll give you a scenario, because partner visa, it's really similar to other visa, but they have one fail or fail criteria. One fail or fail. If the visa, the mother has the argument with the child's biological father and they haven't settled in court, the father hasn't given authority for the child to travel with the mother. but the mother wants to go now, want to lodge now. So do you think we should not child visa? No, we should not add a child at a time, because if the child have issued the consent, then the mother visa will be refused as well. So we don't add it. It's settled. The mother's visa is approved it, and they got settled with, because 445 it would decide it on its own. Would decide it on its own, meaning that once the mother 820 is approved it, or 309 is approved it, the child subclass 445 will be decided on its own. It will be a independent visa application as to my mother's one. So that will be no, one fail, all fail criteria. Okay. Okay, so a definition we have two. One is spouse, which is marriage. Marriage can be taken anywhere. It can be taken anywhere as long as I got married. So under our law, people can get married only, they can be one state at one time. So they can be either married or unmarried. They can't marry twice at the same time. Okay. They can't be in a marriage. So now if the marriage, the requirement is that they have a mutual agreement, mutual commitment as a husband and wife. Okay. And that their relationship is genuine and continuing. And that, I think sorry. Let me just check my cable. I just have issued cable. I can't get charged. Sorry, just quickly run this section. I don't think I can get. Okay, so I think there's a storm. Okay, so for de facto, the requirement is actually really similar. It's genuine and continuing, right? And they have to live apart. That's one. They don't live apart. Sorry, they have to live together and not live together apart for a permanent basis. Okay, of course, that's a requirement, at least 18-month requirement and 12 month. So I just mentioned, if they got certificate, they can waive that 12 month. Okay, they can waive 12 month requirement as well. So some marriage, it's not recognized in Australia. So I think you all understand this has to be our modern understanding of marriage. Okay, so that I don't think that will be some areas of the other countries. I think India, or somewhere else. I don't know, but it's strange. Modern. Okay. Very, very interesting case. Very, very interesting case. That, okay, we have a client who they are cousins. They are cousins. They got married. Okay. Look at my criteria. If they are de facto, they are de facto relationship. The requirement is that they are not related by family. But if they're married, there is no such requirement, which is really interesting, isn't it? When you check this, you see that's so much to play. When they are in de facto and they're not married, they are not allowed if they are cousins. They are related by blood. But for marriage, they can. And a visa can be approved it. Even they are, well, I know, probably sister, brother. They can the tradition isn't in the past. That's a few of societies they do this type of thing. They the cousins may marry together in order to inherit wealth or something like that. It's very common in Western history, isn't it? So okay, so even they are cousins, if they get married, it's fine. Okay, it's recognized here. We don't talk something like that, but we got cases like that as well. In order to demonstrate genuine relationship, we have to demonstrate 4 elements. That's all. We only need to demonstrate 4 elements, which is social aspect, mutual commitment, financial, and nature of household. So don't worry about checklist because you're going to create your own checklist. Don't worry about how the client asks you questions because you're going to know. As long as you meet the residential requirement, but for the purpose of visa approval, you only need to demonstrate 4 elements. And 4 elements can be very creative. Of course, the department gives some policies and guidance on how to demonstrate this requirement, but it's just really easy. So when we say social aspect, meaning that the couple, they are presented and they are shown to other people as a couple. How can you demonstrate it? Very easy. They have photographs, like for wedding party, birthday party, or some kind of church attendance. It's very formal gathering as well. We've got clients who approach us, they just don't understand. 2 of them just took hundreds of photographs with the same clothing and the same tree and doing their selfies. No, with this type of thing. Yes, and they just don't understand because we don't want to see you selfish. I don't care where you go holiday because 2 people can go holiday. They can be flatmates, they can be classmates, they can be anyone. Having holiday together means nothing. If you're a couple, you have to show your social background and people recognize you as a couple. You have a different outlines. Clothing, can we please? Correct. That's correct. Yes, social gathering. They can be having, they support the same team, sport team. The group of people went together for the same event, right? It can be graduate ceremony, university graduation, right? It can be something like that, but don't provide a selfie or some pages of like that. I don't know who they are, right? It's not formal. So this is really important. Department checks photographs. We don't provide them all. We don't provide hundreds, please, because it's a lot of work. We just select 5 to 6 photographs and copy and paste and just list down who are they in the photograph, please. What date happened? What relationship between you and these people? Okay, you can't be, this is a bunch of friends. The best photographs all with their parent, with the parents. The sponsor come to visit the applicant's parents, and they have a very formal gathering. And so because they are recognized by family members. So, okay, so this representing others as which means photograph. Opinion of friends are relative about the relationship. These are actually demonstrated by 2 statutory declaration forms. 2 of them, it can be other side of friends, family, close friends. They're gonna write a statutory declaration, declare that they have known how long for this visa applicant and sponsor, and that they believe they are husband and wife, they are in genuine loving relationship. It's good wording. You have to put a good wording. But the form itself, very simple. It's a form 888. Let me just type here. Okay. So this form 888 wins. The win is gonna write, and the form itself, it's very, very clear outlined what they need to say. Okay. In particular, when they are married, the form 888 have to mention I know they are married couple, this wording, because I've seen colleagues, they got visa refused because the witness did not mention that. But we will have, we were able to see that whether the wording is great. Sometimes the concept genuine sounds same as great. Oh, awesome. I think you got some idea, isn't it? Really similar to your system, I think. So yes, good faith. Smells great. Okay. So but here you have format, which is form 888. You got witness to sign for them. The witness has to be resident. It has to be either of the option. It can be either side. But if they don't have, the two of them have Australian citizen and permanent resident, it is okay as well. Okay. If they have one form 888 signed by Australian citizen and they need to have another form 888 written by other people. So, okay, so if the witness is not Australian, you might need 4 witness statements. Social activities. This can be demonstrated that they go together, gym members, they go together with movies. They went to watch movies. They travel together. They have joint flights. They book accommodations. Bear in mind, after the documents still need to be provided to the department after. So, for example, lodged 6 months ago, and then we just feel, they didn't provide us a lot of evidence. We are a little bit concerned. So what we need to do is we have to tell them, now you guys, when you go out for travel, please put down your own both name and the bookings. Most of the time, booking will say put out one person. On the name section, you have to put John Smith and Carla in the booking. Second guest, you have to put down name on the first clause. For first section, say someone and someone. You have to guide your visa applicant to do this, client. And joint flights, that's evidence. And joint activities. So if the visas they are offshore, so sponsor will be visiting the applicant, so flight to that country. So this it's very important. I think we can't cover all today. Financial aspect. If they are here in Australia, they have to have a joint account. We encourage them just open one. Even you don't have enough money, that's fine. Just open it, go to the bank. Oh, how hard is that? Oh, they rent together, have a rental agreement. If they purchase house together, that of course that's great. And joint liabilities. Joint liabilities means joint phone bills, a joint insurance, legal will is a very strong evidence. Okay, very, very strong one. So you are practicing law, you know this. Mutual legal obligations towards children, something like that. They declare this will be sufficient. Share household expenses. So they go out. So if the case is really weak, they can go out to purchase large furniture. They can keep this. But if they're offshore, they can do the same thing. Sponsor can go back to the country and purchase something for the visa applicant. Mutual agreement, so mutual commitment, sorry, it's how long they been living together. So if the client's flying fly out, then you have to have something else to demonstrate. Natural household. Natural household is really easy. So it's simple. I think you do understand that. You just need to demonstrate who's to cook, who will be to cook, or who is cooking. Who's the cook, who does the household work, who goes to the shopping. Normally we say, oh, we go shopping together weekend. We go watch a movie together, and we take care of kids. Who's going to pick up kids? Something like that. If they're offshore, declaration, you declare that who's going to cook be sufficient. Okay. All right then. Overall, okay. So for temporary visa, we have stages. That 2 years provision waiting time, I mentioned it, can be waived if they can demonstrate a non-term relationship. Non-term meaning they've been together always for at least 3 years. So this be exercised by the case officer under the legislation, which means they will say, oh, visa give you PR because you guys take a very long time. Or it can be done by submission. So if the clients, you believe that they have been together, and I say, look, you might have a chance of a permanent visa, you're going to charge them more for that submission. I've got cases where they live together and they don't have children, but they lived there for 3 years. We got the permanent visa approved. They actually bypass the temporary one, approved within 3 months. So these is cases we can get it. Onshore, the visa applicants are entitled to Medicare, free health, entitled to everything, entitled to the children, entitled to free school. And the visa so A20 visa applicant, okay, they can actually work straight away. They don't need to wait while they're waiting for A20. It's not approved it. They're on bridging visa. They can have a full right. But for bridging visa, okay, relationship will be processed again after 2 years, which is permanent state. If it's not waived it for that 2 years. The temporary visa valid for 2 years. Normally, they don't exercise this because sometimes the applicant forgets. These are numbers not, so we don't have a ceiling for partner visa. I think they are going to strict partner visa, but it's fine. So it's different to skill migration. And I that at the same time the permanent visa. So hence the department can at first permanent visa fee when they lodge the first stage of visa. All right, so I think I still have many slides to cover because we have I think we'll cover next. You have holiday week after. Let's cover week after. Do you have any questions at this stage? I think you. Okay, I need you guys to throw me some questions. Great. I think you have no issue running this type of file. You should do your marketing straight away. You should do your marketing straight away. and it's really easy. Very and watch online as well. All right, awesome. So I think next section, if you do want me to cover about, oh sorry, this is not. Do you want me to cover remaining section, or we skip this one? I do need to cover this sponsorship limitation, and what happened if the visa applicant has been overstayed, and what happens if you want permanent visa right now? Can they be processed? And what is the direction for us to process the visa immediate and request? I've done a lot to get the visa immediate within 1 week. Okay, so all right, I assume, should I just wait for 5 more minutes if you have any questions? Just let me know if you want me to cover the remaining session. So this visa requirement, only partner visa. They have a lot of requirement for partner visa. If for other subclasses, skill visa, and they have a wife, they have a girlfriend, the requirement is very different. Requirement, they do not require the genuine, continuing relationship. You only need to demonstrate that that person is de facto partner of the main applicant, or wife and husband, which is quite lot of standards here in Australia. They don't have enough points. So two of them, even though not married, they are not girlfriend, boyfriend, they join together because the second person can be entitled for extra 5 points if they have a positive skill assessment. No, yes, good question, which I just mentioned. This requirement really hard, terrible, a lot of work. Partner visa only, perspective, onshore, offshore partner visa only. If the dependence it's on, so dependent, what we call dependent, secondary applicant, they are on de facto relationship, they are married certificate, they only need to demonstrate that either they are married or they are in de facto relationship. By definition, de facto relationship, it is that they either live together for 12 months or they get that. Hence, I just said there have been scandals here. You can imagine that two people, for example, they can't get enough points, right? So they just find another one whose occupation is still on the occupation is gets positive skill assessment. So they put that as a joint visa application, even they are not married, because they can just easily get that certificate done within 2 weeks. They can be awarded for extra points. It's different. That they have very, very slight, very, very different processing team and requirements, so different. And for the skill team, they don't look at a dependent factor. They only need to check the visa applicant where has met point system, 65 point. And let me check the work experience. So a lot of scenarios can be happening. You don't. Okay.